Hello, sponsors. I hope you are well. My name is Krista Kartzen. I'm the Senior Director for Sponsorship Initiatives with Welcome.us, and this is a special webinar edition that we're recording on Friday, February 21st, to bring you the latest on what we're hearing about new policies affecting individuals who have arrived in the United States through humanitarian parole sponsorship, specifically Uniting for Ukraine. We've heard from a considerable number of Uniting for Ukraine sponsors with questions about how these policy changes affect sponsored Ukrainians in particular. So our partner, the Ukraine Immigration Task Force, will join us in a bit to address some of those questions. Before they do, I'd like to welcome my new colleague, Manpreet, to our Senior Policy Counsel and Special Advisor to share more about the latest policy updates. Manpreet, thank you for joining us. Now, we know that on January 28th, 2025, President Trump's administration announced a pause to the U4U program, which means Americans cannot submit new applications to sponsor Ukrainians fleeing the war. Pending applications are not being processed, and no new travel is being authorized. A practice alert recently issued by the American Immigration Lawyers Association suggests that President Trump's administration may announce the immediate termination of existing humanitarian parole for individuals who entered the U.S. through parole programs, which could include Uniting for Ukraine, as well as the processes for Cubans, Haitians, Nicaraguans, and Venezuelans. If this occurs, parolees who do not already have another status, such as temporary protected status or TPS, or who do not already have a pending application for asylum or a different immigration status, will be considered by the administration to be out of status and unauthorized to be in the United States. Welcome.us covered these policy updates in previous webinars, and we've advised sponsors and newcomers to apply for any alternative status options as eligible. But a news report recently released indicates that those pathways may not be available. Manpreet, can you tell us a little bit more about this news report and what we know about the policy memo that describes and its potential impact?
Thanks, Krista. We're tracking media reports that on February 14th, the Department of Homeland Security issued an internal memo that suspended decision-making on all immigration applications filed by individuals who arrived in the United States through several programs, including Uniting for Ukraine sponsorship program and the processes for Cubans, Haitians, Nicaraguans, and Venezuelan sponsorship program. The directive, as reported, means that USCIS will not approve any alternative form of legal status many sponsored individuals are seeking while this pause is in place. This includes applications filed for asylum, temporary protected status, employment authorization documents, advanced parole travel, adjustment of status to permanent residence, naturalization, and all other applications filed to USCIS. The memo has not been made public, and there is still a lot that we don't know, including if it'll be challenged in court. As a result, we continue to strongly recommend, per guidance from legal experts, that sponsored newcomers apply for alternative legal status, including asylum if eligible. Sponsors can help by connecting newcomers with legal services. Please check out our guide to legal options for support. We will continue to monitor these policy changes and share updated recommendations as they impact these sponsorship programs. I know that this is also the advice of the Ukraine Immigration Task Force, and I think this is a great segue to pass it back to you, Krista.
That's right. Thank you, Manpreet. Thank you for sharing, and welcome, Anne. Here to help us navigate the nuances of this changing legal landscape is Anne, the Executive Director and Regulatory Counsel of the Ukraine Immigration Task Force. Founded in 2022, the Ukraine Immigration Task Force was first established as a volunteer legal coalition to provide displaced Ukrainians and their support networks with timely guidance and practical resources on U.S. immigration processes. Their work includes publishing materials on immigration law, educating Ukrainians on their immigration options, informing the public of regulatory updates, and providing webinars and clinics, assisting with technical questions, and consulting with nonprofits that serve the Ukrainian American community. And as we are both Ukrainian Americans, I want to add that this week marks the 3rd-year anniversary of the full-scale Russian invasion of Ukraine. We do this work in remembrance of and in support of individuals and families forced to flee their homes, and the compassionate American sponsors all across our country who have opened our homes and communities in welcome. And thank you again for joining us.
Thank you so much for having me here today. I'm very happy to speak about the recent legal developments that pertain to newcomers from Ukraine, where I'm also from. Given the number of policy changes that were implemented rather quickly, I hope to clarify some of the key points and what they mean specifically for Ukrainians who entered the United States with humanitarian parole and their sponsors.
So helpful. Thank you. In that vein, let's jump right in to address some of the most frequently asked questions we've received from U4U sponsors. We've shared a general policy update at the top of this webinar on recent and anticipated changes to humanitarian parole sponsorship. Would you tell us more about how these policies may specifically affect Ukrainians who arrived in the US through U4U?
Sure. So first, I want to mention that the immigration laws themselves have not changed except for one new law that was signed on January 29th by President Trump. It is important to remember that only Congress can pass laws and only Congress can repeal existing laws. So most of the changes we've seen so far affect enforcement or implementation of these existing laws. And these enforcement and policy memos are now directing executive agencies on how to align their priorities and procedures with the president's intended policies. So one of the top goals of this administration is to reduce the number of new arrivals in the United States through humanitarian pathways. A second major goal is to deport individuals who are considered by the administration to be here unlawfully. A third goal is to remove protections for recent arrivals that allow them to stay in the United States. And consistent with these goals, the Trump administration has issued over 60 executive orders since January 20th, with over 15 of them directly impacting immigration procedures. These executive orders led to the publication of official announcements in the Federal Register and memorandum to various agencies. Although Ukrainian recent arrivals have not been targeted as explicitly as certain other immigrant populations, Ukrainians are still affected by the directives that target all sponsored parolee populations. And these include the suspension of all parole programs, including Reparole for Ukrainians and, of course, Uniting for Ukraine. Also, the increasing immigration enforcement of parolees themselves and considerably expanding expedited removal authority for immigration officers. And as Manpreet mentioned, it also includes an administrative pause that we believe is in place on all immigration applications filed by parolees. And this could potentially also include at some point the termination of humanitarian parole status for sponsored individuals in the United States.
Thank you for that overview, Anne. I'd like to double click on what you just shared. Can you explain more about the implications for Ukrainian newcomers here in the US if their humanitarian parole is terminated or if their status expires?
Sure. So if parole status is terminated for all individuals who are currently here on Uniting for Ukraine, this means that they will no longer have a valid status through their humanitarian parole. So if these individuals do not already have another valid status or protection, such as temporary protected status, a pending asylum claim, or a pending green card application, they will be considered to be out of lawful status and not allowed to remain in the United States. I do want to stress that even if parole status is not categorically terminated for everyone who arrived on a sponsored parole program, there are a number of Ukrainians whose parole will expire in the next 3 to 12 months. And the administration ordered USCIS to stop accepting re-parole applications through the online portal. And even applicants who have submitted re-parole requests before January 20th are not receiving decisions. So there's not currently an efficient way to request re-parole or to extend one's parole stay, and this could jeopardize individuals whose parole is set to expire this year. So the bottom line is Ukrainians who lose their parole status, either because it expires or is terminated by the Department of Homeland Security, no longer have lawful status in the United States. And this could expose them to added risk of immigration enforcement and even potentially deportation.
Last month, we sent out an email to our humanitarian parole sponsors explaining that on January 23rd, DHS issued a notice directing immigration officials to begin the process to remove individuals from the U.S. back to their home country if their humanitarian parole has ended and if they haven't applied to an alternative status, just as you mentioned. To your knowledge, has this actually affected newcomers who have arrived through U4U, or is there a possibility that it could?
There are some Ukrainian parolees who may be subject to expedited removal. And expedited removal is a protocol by which immigration officers, rather than a judge, decide whether to remove an individual quickly through administrative channels with limited due process or access to legal counsel. Although expedited removal has been around for almost 20 years, the Trump administration implemented policies that removed some of the barriers to using expedited removal and broadened both the scope and the categories of individuals who are subject to expedited removal. So Ukrainian parolees who have been in the United States for less than 2 years could be subject to expedited removal. We have heard of this happening to Ukrainian parolees specifically, and we urge sponsors to take a look at our Ukraine Immigration Task Force website for more information on expedited removal and what to do if it happens. And I want to stress that expedited removal through the Department of Homeland Security is different than standard removal proceedings through immigration court. So ideally, to protect themselves, parolees should carry their attorney's business card at all times to present in case they are detained. And alternatively, they can carry a Form G28 representation form that's signed by their attorney. And it's also a good idea to carry proof of any pending immigration applications. For more specifics on expedited removal and also standard removal proceedings and what to do if it happens to somebody that is in the parolee community, you can go to our Ukraine Immigration Task Force website.
Thank you. And I know we'll be sharing that in a bit on screen. I'd like to talk more about what options are actually available to sponsors and newcomers to help avoid a scenario like this. We know there are alternative status options for folks who entered the U.S. through humanitarian parole sponsorship. We hosted a previous webinar exploring some of these options and developed a guide which is available on our website. But we've had sponsors ask us more about Ukrainian newcomers in particular. What options do they have and what pathways are actually most feasible, especially given this reported pause in application reviews?
So temporary protected status, or TPS, is one potential protection for Ukrainian parolees. And TPS is open to nationals of Ukraine or those with no nationality who last habitually resided in Ukraine. It is not open to citizens of other countries who resided in Ukraine. which presents a challenge to certain families who came on U4U with mixed citizenships. In order to qualify for the current term, Ukrainians must have arrived on or before August 16th, 2023, and have been continuously residing in the United States since then. Ukrainians who were previously granted TPS that has expired may also file a new application. And the current term of TPS actually began August 21st, 2023, and was set to expire April 19th, 2025. But on January 17th, 2025, the Department of Homeland Security under the Biden administration published an official notice of extension of Ukraine's TPS designation, for temporary protected status. And this 18-month extension begins on April 20th, 2025, and ends on October 19th, 2026. It's important to understand that this extension does not open eligibility to a new pool of applicants. It only extends the period of protection for Ukrainians who already have TPS or are already eligible to apply under the current term. So Ukrainians who already have TPS, and a number of parolees do, can apply to re-register their TPS through March 18th in order to extend their TPS status through October 19th, 2026. For Ukrainians who are applying for the first time, initial TPS applications will be accepted throughout the end of the current term, which is April 19th, 2025. Ukrainians who are not able to file an initial TPS application by that date are still allowed to file up through the end of the extension period ending in October 2026, but those who file after April 19th of this year will be considered late filers. And those who are filing late must meet the late filing exception and submit a letter explaining why they're filing late. And additionally, they risk having expired status until and unless their TPS is granted. However, as you and Manpreet mentioned earlier, USCIS has suspended decisions on all applications that are filed by parolees. So even if Ukrainian parolees file a TPS application in time, they may not get a decision for a while since we don't know how long the pause will be in place. And if USCIS does resume issuing decisions to parolees, then Ukrainians who already filed for initial TPS and are approved will be granted TPS through October 19th, 2026. I also want to point out that simply filing for TPS does not in itself provide a lawful status. So Ukrainians who have applied for TPS but have not yet received approval from USCIS are not protected from immigration enforcement or detention just because they filed a TPS application. So if their parole or visa stay has expired but they have not yet been granted TPS, they are not in lawful status. They could potentially be protected from accruing what is called unlawful presence, which could preserve their right to apply for future immigration statuses. But the simple fact of filing a TPS application does not insulate them from deportation.
I see. Thank you, Anne. You shared a lot of dates, a lot of good content there. I think I caught that folks are eligible to apply for TPS if they arrived in the U.S. Before August 16th, 2023. What about the individuals who arrived after August 16th? Is there any grace period for them to apply?
Unfortunately, the law is very strict about TPS eligibility. USCIS routinely denies TPS applications from individuals who don't meet the precise dates of entry and continuous residence in the United States. So for now, The cutoff is Ukrainians who entered on or before August 16th, 2023.
Okay. Following up with just one more TPS question. Ukrainians currently on U4U who will be applying for TPS, if approved, will they receive temporary protected status only through April 2025, or will they receive it including that 18-month extension that you mentioned?
That's a good question. For now, both the TPS designation and extension remain in effect for Ukraine. So Ukrainians who already filed or plan to file for the first time will be granted TPS through October 19th, 2026, if approved. Ukrainians who applied to re-register their TPS will have their TPS status extended through October 19th, 2026 as well. We're, of course, watching Ukraine's TPS designation closely since one of the January 20th executive orders requires the Secretary of Homeland Security to review the TPS designations of all countries to make sure that they align with the administration's policies. And we did see that both Venezuela's and Haiti's extensions were terminated. And this could potentially happen to other countries, such as Ukraine. But as of today, no changes to Ukraine's TPS designation or extension have been announced.
Thank you. So asylum is also on our list of alternative status options that newcomers may explore pending eligibility. But we've heard from a number of sponsors that Ukrainians don't think they're necessarily eligible for asylum. So on their behalf, I'm asking you, as an immigration attorney, is asylum a viable option for Ukrainians sponsored through humanitarian parole?
Yes, we get a lot of questions asking if Ukrainians can apply for asylum and if they should apply for asylum. So I will discuss this in a general context, but keep in mind that every single person who is considering asylum has very unique circumstances, and it's not possible to give recommendations as a whole. So with that said, asylum could be an option for certain Ukrainians. Asylum is granted to individuals who cannot return to their home country due to past persecution or a well-founded fear of future persecution because of their race, religion, nationality, political opinion, or membership in a particular social group. The persecution must be inflicted by their home country's government or by an entity that their government is unwilling or unable to control. Parolees who are not in removal proceedings may apply for affirmative asylum through USCIS within 1 year of their arrival into the United States. Those who have maintained a valid humanitarian parole status, TPS, or another valid immigration status may qualify for an exception to the 1-year filing deadline, but it is recommended that those who qualify for the exception try to file their asylum application as soon as possible. If Ukrainian parolees decide to file for asylum, they should keep in mind that affirmative asylum applications are also suspended for parolees, including interviews for asylum. This could mean even longer wait times before getting an interview and going through the other required steps. Parolees who are in removal proceedings may apply for defensive asylum directly to the immigration court. Their asylum claim will be heard while their removal case is in progress. As far as the merits of an asylum claim, this really depends on the applicant's individual facts and circumstances, as I mentioned. Generally speaking, asylum is a difficult case to pursue, and the chances of asylum actually being granted for any applicant are relatively low statistically. So the outcome depends not only on the individual merits of an applicant's case, but also on discretion of the asylum officer or the immigration judge, depending on which type of asylum they're applying for. Some individuals have better chances than others based on their unique history and the strength of the evidence that they can present. So I want to stress a very key point. Fleeing war or violence by itself is not a sufficient qualification for asylum unless the applicant meets other eligibility requirements. An applicant must be able to demonstrate that she or he suffered or will suffer persecution if returned to Ukraine. And that persecution must be significant, such as unlawful or political detention, torture, violation of human rights, physical violence, or some other type of severe non-physical harm. And the applicant also needs to show that the reason for the persecution is on account of their race, religion, nationality, political opinion, or membership in a particular social group. So even if a Ukrainian parolee can provide sufficient evidence of past or future persecution because of one of these characteristics, they would still need to establish that the Ukrainian government or an actor that the Ukrainian government is unable or unwilling to control is inflicting this persecution. This could be challenging for some Ukrainians to show. Speaking from an asylum officer's point of view, the Ukrainian government is considered by the US State Department and many refugee organizations to be fairly tolerant toward religious and ethnic minorities, as well as people of other nationalities, political dissidents, and the LGBTQ community. In addition, women have equal rights and strong representation in Ukraine's government. The press has freedom of speech, and Ukraine maintains elections and democratic processes. So Ukraine is considered by the State Department and non-governmental organizations to be a very socially progressive country. With that being the general perception from our government's point of view, there could very well be individuals in Ukraine who have experienced significant persecution because of one of the protected characteristics of race, religion, nationality, political opinion, or membership in a particular social group. It's possible that they could have experienced this at the hands of local government officials where they lived, or perhaps officials in various administrative positions in Ukraine's government. Another possibility is that some Ukrainians experienced persecution because they lived in areas that are or were occupied by Russian forces or mercenaries, or potentially mercenaries from other countries or non-governmental groups. Other people could potentially argue that their race, religion, nationality, political opinion, or membership in a particular social group exposes them to a legitimate risk of future persecution in an occupied or targeted territory of Ukraine. So I know that that's a lot of information, and I want to stress again that these are hypothetical examples that could potentially be considered. It doesn't mean that a person with these characteristics, will be successful. And certainly there could be other potential characteristics that could be persuasive. So I want to stress once again that asylum is very fact specific for each person. So, without learning the details of a person's history and reviewing some of their evidence, it's not possible to assess their personal asylum claim.
Thank you for just giving us a glimpse of what that could look like. A few sponsors are also curious about what re-parole looks like for those who may be eligible, especially given that categorical humanitarian parole is paused. Is re-parole even still an option?
Right now, right now, USCIS is not processing any re-parole applications through the streamlined online process for Ukrainians that had been opened in February of 2024. And Ukrainians who applied for re-parole through that online process, excuse me, in the past few months may be stuck waiting indefinitely until or unless Ukrainian re-parole is resumed through that process. However, humanitarian parole as a whole has not been eliminated since it is provided for in the immigration laws themselves. So, what Ukrainians would need to do right now, if they are hoping to receive re-parole, is they would need to apply through the traditional process by filing Form I-131 to USCIS and submitting all of the required documentation. Form I-131 is the standard form used to request both parole and re-parole to USCIS. And so applicants should clearly indicate on Form I-131 that they are applying for re-parole, and they will need to provide all the necessary supporting documentation proving their previous parole status and the reason they are requesting another grant of parole, which is called re-parole. They will also need to provide urgent humanitarian reasons or significant public benefit that justify a new period of humanitarian parole. And they will also need to explain why they are in it, why their unique situation warrants a favorable discretion by the Department of Homeland Security, which is basically a way of asking why this applicant in particular should be allowed to stay in the United States on parole. And their re-parole requests will then be considered on a case-by-case basis after examining their individual circumstances to determine if another grant of parole is warranted. I do want to mention that this process can take a very long time. Traditionally, processing for Form I-131 has been, taking anywhere from up 8 to 10 months. Right now, we're seeing 12 to 15 months, and that's according to the USCIS processing estimates. So it could be 12 to 15 months or longer. So it may or may not be a feasible process to request re-parole for Ukrainians whose parole is expiring soon. And as a reminder, there is a pause on the final adjudication of re-parole requests. So there could be a further delay on any re-parole applications that are already in the pipeline.
Got it. So we've had sponsors asking if there's a way for individuals who came to the US through U4U to apply for permanent residency or citizenship. Are there any options for these folks?
Yes, some Ukrainians may be able to apply for permanent residence, or it's called a green card. This is called adjustment of status for permanent residence, and it's done by filing Form I-485. Right now, USCIS has paused adjustment of status applications and interviews, along with the other applications from parolees. So unfortunately, this may not be accessible right away. But generally, Ukrainians can apply to adjust their status if an immigrant visa is immediately available to them at the time they file their adjustment of status application. The most likely way for parolees to obtain a green card, excuse me, is through family-based immigrant visas. This option is open to parolees who have qualifying relatives that are U.S. citizens or lawful permanent residents. And the fastest route is to be sponsored for a green card by what is called an immediate relative. This is limited to a U.S. citizen spouse, a U.S. citizen parent, if the applicant is under 21 years old and unmarried from Ukraine, or a U.S. citizen child who is at least 21 years old. So these are sponsors for immediate relative petitions. There is no waiting period for immediate relative visas. but the interview and processing time could take 1 or more years right now, since USCIS has a very high backlog and unfortunately has a lot of applications to go through. So Ukrainians who do not have an immediate relative sponsor, but who have parents, children, brothers, or sisters that are US citizens or lawful permanent residents may apply for a family preference visa. These visas can take up to 6 to 10 years to become available due to the extremely long waiting lists. That does not include the processing time for the adjustment of status application after the visa becomes available. So while this could be an option for some parolees, I want to point out that the family preference visa categories may not be available in time for a parolee to wait for while they're on parole, and possibly even while they're on TPS, depending on how long that continues. So Ukrainian parolees may have to leave the United States when their status expires and pursue a visa through the US consulate abroad.
I see. Another frequent question from sponsors is whether it's possible for an employer to sponsor Ukrainians with humanitarian parole for a work visa. Is this a potential option?
This is a very common question we get asked. So a lot of employers are actively seeking workers with certain skills, and a lot of Ukrainians have these skills. Unfortunately, under the current immigration regulations, parolees are not allowed to seek employment-based visas if they have not left the United States since they entered on humanitarian parole. So there are two types of employment-based visas. There are immigrant visas and non-immigrant visas. So that temporary worker visas or non-immigrant visas are not available to individuals who enter on parole because parole is not the type of status that can apply for a non-immigrant visa in the United States. Now, with regard to employment-based immigrant visas, which are designed for permanent residents, unfortunately, parolees are not eligible to apply for the adjustment of status through an employment-based immigrant visa. So in either case, Ukrainian parolees would have to leave the United States in order to pursue an employment-based visa. One way to do this is to apply to a US consulate abroad in their home country, and then, wait until they're approved in that way. Or they could also go to what we call a third country, and they would have to establish residence and apply through the consulate there. Another potential way that Ukrainians could apply specifically for employment-based visas is to be approved for temporary protected status. They would then have to apply for and be granted a TPS-specific travel document, but they would still have to leave the United States, return, and be admitted on TPS status. And at that point, they would no longer be parolees. So this would theoretically remove the legal bar that prevents parolees from applying for employment-based adjustment of status. But this is a hypothetical avenue because some of the regulations and procedures changed fairly recently for TPS and parolee travel, and we haven't had time to test whether parolees who get TPS and return on TPS travel are successful in applying for employment-based adjustment of status. So this is a potential avenue, but I think the short answer is that employment-based adjustment of status or employment-based temporary visas are not an option for parolees unless they leave the United States.
I see. Thank you so, so much for your insight, Anne. What I've learned from you today is that Ukrainian newcomers may be eligible for a variety of alternative legal status options, although the availability and timeline of these pathways are uncertain. And if newcomers choose to apply for an alternative status, they should do so with the help of a competent immigration attorney. And there are things they could do in the meantime, such as carry their attorney's business card or a G28 representation form signed by their attorney, as well as proof of any pending immigration applications. Can you tell us once again, where can sponsors find out more information on the Ukraine Immigration Task Force and the new resources you're producing?
Sure. So we have a number of resources on our website, and sponsors and parolees can visit www.ukrainetaskforce.org and click on the resources tab and then select resources in the United States. And they can also read some of the more recent immigration news updates by clicking on the news and events tab and selecting legal updates. And finally, they can follow our Facebook page and Telegram channel for other news.
Fantastic. Thank you. We're so grateful that you and the Ukraine Immigration Task Force have been so generous in sharing your expertise with our sponsors. And to stay updated on the latest private sponsorship updates, take a look at our policy page, which includes resources like our guide for navigating alternative status options, our guide for contacting your congressional representatives, policy explainers, and frequently asked questions like those we explored today. You'll find our website right at www.welcome.us. I want to thank again my colleague Manpreet Teji and Anne Smith with the Ukraine Immigration Task Force. As things change, Welcome.us strives to be a center of gravity for welcomers across the country to find belonging, connection, and resources. I hope you found that to be the case in this webinar. Thank you for your time, and be well.